Hello students, welcome to the business law session for B.B.A 5th semester. In our previous class, we were discussing about one of the important element for the valid contract, that is consideration. We had studied about the definition of the consideration, the meaning of the consideration, the rules pertaining to consideration, and the consideration must be lawful consideration. So we had here discussed these aspects. Now I am coming to the last aspect of the consideration, which is a 5 marks question from your examination point of view. This here question is: no consideration, no contract. State the exceptions. So this is the question you will be having for your examination. No consideration, no contract. This is a general statement I am making, that without consideration you cannot make a contract. Hence, consideration is most essential part. That is, here both the parties here of the contract. So to make a contract we must have two parties. Both the parties must get something in return. They must have something in return. It may take any form. Adequacy is not important, but both must be here getting something in return, that is consideration. So consideration is the nucleus of the contract. Without that there is no contract. This is the statement, but there are exceptions where we find sometimes the consideration is missing, but still the contract is valid. So the law imposes mainly the obligation. The law says that there is a contract here. It is presumed from the circumstances that here is a contract. So no consideration is lacking here. The consideration is lacking, but here still the contract is valid and it can be enforceable in the court of law. So what are those exceptions to this rule? We will try to understand. First, in 2 lines you mention no consideration, no contract, as it is most important element of the contract. Without consideration there cannot be a contract. Both the parties to the contract must get something in return. But there are certain circumstances where the consideration is lacking here, but still here the contract is enforceable in the court of law. It is valid. So give this 3 to 4 lines here, mainly the beginning, and then you write here the circumstances under which here the absence of the consideration makes the contract valid. So the first one is agreement made out of love and affection. Agreement made out of love and affection. So now here any agreement which is made out of love and affection from one party to another, no consideration is moving from one party to another. So it is out of love and affection that here agreement is made. So in this case, here the person making is mainly giving something, but he is not getting in return anything. It is out of love and affection he will be making. But there are certain requirements for this. Here this agreement becomes enforceable in the court of law, here which is made out of love and affection, if there are certain criteria present in that. The first thing, the parties must be standing in near relations. Near relations, I am using the word, students, not blood relation. It may be blood relation, it may be close friends. Here the relation that persists between here the promisor and promisee here must be very near. So near relation, it may be any type of relation. Any type of relation here. That is, it may not be blood relation itself. It may not be blood relation. So the parties must stand to each other in near relation. And the promisor must have executed the agreement out of love and affection. Out of love and affection. And that must be put in writing and it must be registered. It should be put in writing. So requirement is that any such agreement which is made out of love and affection cannot be accepted orally. It must be put into writing and it must be registered. Then it is valid. Here without consideration. It is a valid here. So other party, for example, A makes here out of love and affection. He mainly gives certain things to B, certain goods to B. Out of love and affection, he puts it in the writing and gets it to the register that so and so. Here, goods having given out of love and affection to here B. So the agreement is made and it is put in writing and it is registered. And the persons A and B are standing in very close relation. It is valid. Though consideration is not knowing that. From B, nothing is coming back to A for what he is giving. So the consideration is lacking, but still here in the eyes of law it is a valid contract. Because it is made out of love and affection and the parties are standing in here near relation and they have here entered into that writing which shows that they are bound by the terms and conditions, the legal obligations. Hence, it is considered to be an exception to this rule, no consideration, no contract. This is the first one, you have to know it. Second one, agreement to compensate past voluntary services. Compensate, here, past voluntary service. So, if a person has rendered some service to another, here it should be voluntary service. It is not here on the call of the person the service is to be rendered. It is a voluntary that person renders the service. And any agreement to compensate it, here, then it is valid, though there is no consideration. Because the first thing you should remember, you are mainly the person is rendering the service voluntarily. Without being asked by anyone, he is mainly doing the service. So, voluntary service, there is no question of he is not expecting anything in return. The person is not expecting anything in return. For example, A here mainly sees that B's house is on fire and immediately, voluntarily he goes to extinguish the fire there. B has not called him to come and help. So, but A voluntarily goes and helps B in extinguishing the fire and he saves the house. B says that you have saved my house from burning out and I will compensate your voluntary service, and an agreement is entered. This agreement, because the person is not expecting anything there in return. So, any such agreement to compensate past voluntary service, already the service might have been done there. The service is done. For example, A has rendered here a tuition to B's house, B's son C. Here voluntary has rendered without expecting anything in return, remuneration. But B here afterwards he says that you have rendered the knowledge to my son, hence I will compensate your service. So it is a past voluntary service. So this is very important. That person must have done it voluntary. The service rendered must be voluntary without expecting anything in return. Nothing here to be here expected in return. So that is agreement to compensate past voluntary services. This is mainly without a consideration and it is here mainly a valid contract. So once you make this agreement, here later that person in whose favor the agreement is made, he can claim here the execution of the agreement. It becomes a valid contract there. Then you cannot take the contention that there is no consideration more, because already you have entered into an agreement to compensate the past voluntary services. That person was not expecting anything. You have come out that you are giving for his service, and later you cannot go back on your words there. This is what is the second exception. Third, agreement to pay time barred debt. Agreement to pay time barred debt. So this is another example now we will be seeing here as an exception. So any debt which is given is recoverable as per the Limitation Act, 3 years. The duration is 3 years. Any debt that has been given, the person who has given the debt, he has got 3 years to recover his debt. Once the expiry of 3 years, then he cannot recover it. We say that the debt is barred by the limitation. So that is the word, time barred debt. Time barred means it is barred by the limitation Compensation Act. The Act says that 3 years, within that you should file a case to recover that amount. You should not make a delay. Here a lot of time is given. In spite of your negligence, if you have here not done it, here then you have to sustain the loss. But 3 years time is there to recover the debt. Now what we find is the time bar debt has gone. A has given a debt to B and 3 years have passed out. So the debt has become time barred. A cannot recover the debt. But B comes forward and says that you have given me when I needed it and I will pay your time bar debt. Agreement to pay time bar debt. Already the debt time has expired. The debt time is already over. Now there is no question of here A claiming it here against B. If he goes against B, here B can take the contention and say that here it is time barred, here I am not here entitled to pay it. But B, he says that in the time of crisis you have given me the money and you have helped me, and though it is time barred, I agree, I make an agreement that I will pay your time barred debt. Then that agreement is enforceable. Though there is here no consideration moving. There is no consideration moving. Now see that person has come voluntary and he has said that I will pay. He will be not getting anything in return. Already he has got that money, but that is time barred. He can escape the liability, but he says that I will give it. Then it becomes liability. Then the person can claim that though the time barred debt. This is here an exception to no consideration, no contract. Completed gifts. This is another. Gift. So where a person makes a gift is called as a donor, and one who receives the gift is called as a donee. So these are in specific contracts. Here these terminologies has been used. Instead of using the word promisor and promisee, we use the word donor and the donee. So completed gifts, not only gifts, but the word is very important. The prefix word what we are using is completed gifts. Completed gifts. So gift is something which you willingly give it to another, not expecting anything in return. So when you make a gift, you are not expecting anything in return, you make the gift. Willingness, you are willingly giving that here to another person. Donor giving it to the donee. This is here what we call it as a gift. Now completed gift. So it should be completed. Means that the gift deed must be put in writing, it must be registered. The gift deed must be made, that is it should be put in, the gift must be put in the writing, that is most important, and it must be registered. Then we call it as completed gifts. So completed gift, it is put in the writing. Now for example, A mainly makes a donation of his furnitures to an educational institution. So he gives it to himself. So he puts it in the form of writing, in the form of a deed. Here it is presented and it is registered and it is given to the school authorities. So that is completed gift. He has donated the furniture to the school. Later, here he mainly says that I have given you the furniture, pay the amount of that. He cannot do it. Because he is not expecting anything in return. It is giving his willingness. Through his willingness, he is giving those here the furniture to the school authorities. So he is not asking the price of that. If it is a price, then it becomes commercial contract, and there is here nothing here mainly as an exception. And here this also the case. We should know that here if he later if he makes the gift and later he claims the amount, it is not here. The school authorities have got every right to retain those here the furniture as it was a gift. Yeah, but it should be a completed gift, put in writing, and then it must be registered. This is another exception you have got. Such exceptions will be there. So when you find it, try to give one simple example. Hypothetical examples you can give. See, it is a 5 marks question. Here, hardly each exception you have to answer in 2 to 3 lines. Within 2 to 3 lines, you have to complete your answer. So bear in the mind, here first you have to mention about this doctrine which has been laid down, and then you write the exceptions in 3 to 4 lines and with the examples. The next one is creation of agency. In creation of agency, we do not have any consideration. For example, A appoints B as his agent. The agency is created. B has become the agent of A. So nothing is stated. What work B has to do is not mentioned by A. Neither A has mentioned what will be the remuneration for the agent. B has agreed and the agency is established. So no consideration is going. Section 185 of the Indian Contract Act says in the creation of agency, no consideration. Section 185 of the Indian Contract Act mentions that the consideration is not moving or it is not required in the creation of agency. Later, here when the agency is created, then the principal here gives the responsibility to the agent. He assigns the work and fixes the commission to be given there. Then that is a different thing. So in creation of agency, here directly B cannot, here as you have appointment a agent and you give me the commission, he cannot say. Because still nothing, terms and conditions of the agency have been laid down. Just agency is created. So in the creation of the agency, we do not require the consideration. That is also here one more exception. The last one, acted to be done by one person, done by another. This is also here an exception to this no consideration, no contract, the last one. So the act to be done by one person is done by another on that person's behalf. Here the consideration is not that, here mainly the thing. For example, it is enforceable in the court of law. It cannot by the want of consideration, this cannot be dismissed in the court of law. Here there cannot be a contention that there is no consideration. For example, A has taken a lease of B's house for 5 years. A has taken the lease of your B house for 5 years and the lease amount is paid every year. So for 5 years he has paid the 1 year lease amount, and B is out of station. And the municipal authorities have issued the notice in favor of B that his house tax is pending for 2 years. And if it is not paid immediately, here the house will be confiscated. The confiscation notice is given. So A is staying in the house. He has to protect his lease, but he is not required to pay the tax. It is the person who has to pay. The owner has to pay it. B has to pay it. On his behalf, A pays that tax to save his lease, and later he claims that amount from B. B cannot say, I have not asked you, no consideration is moving from you to me, no consideration is moving, why I should pay to you? B cannot say so. Here the act to be done by that person is done by this person. So look at the circumstances. Who is entitled to pay that? It is here B has to pay that. He is the owner of the house as he is out of station. Otherwise, here his house will be confiscated and this person will be thrown out. There are two things to be understood. Confiscation of the notice is there and the house will be sealed and this person will lose the lease. So both are taking into consideration to save his lease and to save the owner from here the house to be here sealed. He has paid the tax. Hence, he is entitled to claim that amount from him. B cannot take the contention that there is no consideration from A here. He cannot. He has saved that, mainly the sealing of the house there. Otherwise, the municipal authorities would have sealed that, mainly the house. Like this, the work to be done by one person is done by another. And that is the exception, the last exception we have got. So totally we have the 6 exceptions to this rule. No consideration, no contract. This is a 5 marks question from your examination point of view here, and in the conclusion you write that here such agreements, though there is a lack of consideration, here still they are considered valid and they are enforceable in the court of law. This is how you have to end your answer, and this ends the topic on consideration. and the next element we are taking is about the consent or free consent. In my next class I will start with it. Thank you.